So let's get into this white paper, ladies and gentlemen. Leadership matters here. Leadership matters, guys. Now, the government of Antigua, white paper on U.S. proposal, right? For arrangements to transfer third country nationals removed from the United States. This is an official document, my people. All right, so we're gonna get through it. Let's listen.
Executive Summary. This white paper explains the position of the government of Antigua and Barbuda on proposals from the government of the United States concerning the possible reception in Antigua and Barbuda of certain third country nationals removed from the United States. The government of Antigua and Barbuda has approached this matter in a spirit of friendship and cooperation. It did not refuse to consider the request when it was first raised, because Antigua and Barbuda values its relations with the United States and recognizes the importance of serious engagement between friendly states. At the same time, Antigua and Barbuda is a small state with limited land area, limited public resources, and limited absorptive capacity. It cannot responsibly accept open-ended obligations involving persons who are not its nationals and whose removal is sought by another state. Antigua and Barbuda has willingly cooperated with U.S. Immigration and Customs Enforcement, ICE, in accepting the return of its nationals who have been deported from the United States. Between March 2025 and July 2026, Antigua and Barbuda accepted the return of all 5 of its nationals identified by ICE for deportation. The government's position is therefore clear. Antigua and Barbuda will not accept a standing program for the reception of third country nationals, which is to say, nationals of countries other than Antigua and Barbuda. Any cooperation can be considered only on a strictly limited, case-by-case basis, in the exercise of Antigua and Barbuda's complete sovereign discretion. Any person proposed must be fully documented in advance, must satisfy strict eligibility conditions, and may be refused by Antigua and Barbuda for any reason. No person should depart the United States unless the full cost of reception, settlement, healthcare, welfare, security, administration, and any onward or return arrangements has been secured in writing in advance by the United States or another acceptable agency. In light of Antigua and Barbuda's size and capacity, the government's counter-proposal contemplates no more than 10 persons in 2026, followed by a review in 2027. The purpose of this white paper is to inform Parliament and the public of the background, the issues at stake, and the principles on which the government has proceeded. July 9, 2026.
So, ladies and gentlemen, that is a mouthful. Only 10 persons for 2026. Strict conditions. Money for all different things. So the leader of Antigua and Barbuda is being very meticulous, very detailed. You understand? We have another die-hearted agent of darkness come on the TikTok platform. And they most of the time they always come on some page where them not have no face, them just some username or something like that. But the TCND, ladies and gentlemen, you see the approach that Mr. Gaston Brown has made, putting out this white paper for the public to let them understand what is the position of the government. Will we see same with this government? I doubt it. But let's continue. Very interesting.
July 9, 2026, St. John's. 3. 1. Introduction. This white paper is presented by the government of Antigua and Barbuda to inform Parliament, and the public of the issues arising from discussions with the government of the United States of America concerning the possible reception in Antigua and Barbuda of certain third country nationals removed from the United States. The matter is important. It touches directly on sovereignty, immigration control, public finance, national security, social stability, and the international legal obligations of Antigua and Barbuda. It also raises a wider question of fairness. Antigua and Barbuda, like every sovereign state, must regulate entry into its territory and determine who may remain there. But it is one matter for a state to receive its own nationals who are returned from abroad. It is another for a small country to be asked to receive and settle persons who are not its nationals and whose removal is sought by another state. The government considers it necessary that Parliament and the public be fully informed of the background, the issues, the principles that guide Antigua and Barbuda's approach, and the terms on which any cooperation could responsibly be considered. This white paper is written in a spirit of candor and friendship. The United States, like every sovereign state, is entitled to regulate its borders, determine who may enter and remain in its territory, and enforce its immigration laws. Antigua and Barbuda respects that right. At the same time, Antigua and Barbuda is equally entitled to decide whether, and on what terms, it can responsibly receive persons who are not its nationals and whose removal is sought by another state.
Hey, let me tell you something, man. This is intelligent leadership. I mean, this is not a hostile. This is a firm, not crossing any boundaries, stating the legal facts of the matter, understanding you're dealing with the eagle, but still standing strong on principle and framing it in such a way that any reasonable person have to appreciate this in the leadership. You know? America is a sovereign state, so are we, Antigua. And they have a right to decide who comes in and out of their borders as well as we do. You see what they did there, ladies and gentlemen? This is a teacher. This is somebody that is not compromised, you know. That America have no dirt pan. So they can be bold enough to stand up with their head held high and not crawl upon them belly like Andrew and his government. Let's continue.
State. 2. The critical issue of third country nationals. What is their status? The critical issue for Antigua and Barbuda is, what is the status of third country nationals who are transferred to Antigua and Barbuda? This is an important question that strikes at the heart of Antigua and Barbuda's legal exposure. The answer involves several overlapping status categories, and the picture is genuinely complicated. The immediate status upon arrival, legal limbo. A person who arrives in Antigua and Barbuda without valid travel documents, transferred under an agreement between the U.S. and Antigua and Barbuda, does not fit neatly into any existing category under domestic Antigua and Barbuda law. Antigua has no Stand-Alone Refugees Act. Asylum claims are handled ad hoc under the General Immigration Act, with protection access determined informally in 4. Cooperation with the United Nations High Commission for Refugees. This means the person's legal status upon arrival would be administratively indeterminate until the government makes a specific designation. What could designations be? The 3 possible designations. 1. Asylum seeker/refugee if the person expresses fear of return to their country of origin, Antigua and Barbuda's obligations under the 1951 Refugee Convention, to which it acceded on September 7, 1995. Are immediately triggered. The person must be allowed to apply for protection and cannot be returned, including to the United States, if doing so would expose them to persecution. This means that the person would be in Antigua and Barbuda in limbo and would become a charge upon the state. 2. Stateless person if the person has no valid travel documents and refuses to apply for a passport from their country of origin, they may effectively be or become stateless in practice, even if technically they retain a nationality. This triggers a separate body of law. Antigua and Barbuda succeeded to the 1954 Convention on the Status of Stateless Persons on October 25, 1988, which
Jamaica, you remember when Mark Golding came out and he raised concerns about the TCN deal, the legalities, the international law. That was one of his main issues because it was in court and, it was determined that it was illegal and in one of those states in America, and there was an appeal. And I said it before and I'll say it again. This government will hold a report because of sub judice, but they will continue to discuss a deal while there's an appeal of a ruling that affects the deal negatively. And I don't understand the logic behind that. When they are supposed to be careful about real legal issues, right? They choose to be bold. But when it comes to stamping out, corruption in the country and exposing persons that are involved potentially in illicit enrichment, they want to hide these reports and take as much time to table them as humanly possible to squeeze it out. Remember what happened with the FLA report, right? This is the modus operandi of this government, and we have Fear and Queen locking down. One of them is the two most powerful position, the Prime Minister and the Speaker of the House, all under one roof, right? Asylum seekers. If a person expresses fears to return. This document is quite detailed. Let's continue, guys. Very informative.
obliges it to issue identity papers to any stateless person in its territory who lacks a travel document. Issue a convention travel document, CTD, to stateless persons lawfully residing in its territory, a document recognized internationally and used in lieu of a passport. Accord stateless persons treatment at least as favorable as that accorded to nationals in matters of religion, and no less favorable than that accorded to aliens generally in matters of work, housing, and public education. Critically, Antigua has not acceded to the 1961 Convention on the Reduction of Statelessness, so there is no legal mechanism under domestic law to resolve statelessness, only to manage it. But managing stateless persons can become a huge cost to the state. 3. Undocumented irregular migrant if the government does not recognize the person as a refugee or stateless. The default under Antiguan and Barbuda law is that they are an undocumented non-national subject to detention and deportation under the Immigration and Passport Act. But this presents a legal trap if the person cannot be deported to their country of origin because that country refuses to take them or because doing so would violate non-refoulement 1 and cannot be returned to the United States. They become non-removable, trapped in indefinite detention or irregular status. One non-refoulement is the principle of
Jamaica only hear that? It is a legal trap. A legal trap, ladies and gentlemen. Mighty God. This part of the undocumented irregular migrant. If the government does not recognize the person as a refugee or stateless, the default under the Antigua and Barbuda law is that they are an undocumented non-national subject to detention, right? Under the Immigration and Passport Act. But this presents a legal trap if the person cannot be deported to their country of origin because of the country refuses to take them, or because doing so would violate a revolvement, a non-revolvement. Hold on, no man. Because the country refuses to take them, or because doing so violates non-revolvement. I've never seen that word before. Is it revolvement? and cannot be returned to the United States, they become non-removable, trapped in indefinite detention or irregular status with no legal pathway forward. Antigua and Barbuda would then be confronted with persons who will have to be supported by the state for the foreseeable future. Jeez, some peace. Hey, Jamaica, open up your attention. How much time gone for the reaction already? 15 minutes, we can do 15 minutes more for part one. No, sir. Let's continue. Hopefully, we can finish it, guys. Yeah. Hopefully, we can finish it. This is quite interesting, ladies and gentlemen. Quite interesting indeed.
With no legal pathway forward, Antigua and Barbuda would then be confronted with persons who will have to be supported by the state for the foreseeable future. The travel document problem. The Regional Security System, RSS, chairman directly flagged this issue in April 2026. If the TCNs did not have valid travel documents issued by their home country, they could not return home. Why would a home country issue a document for them? The U.S. position is that the International Organization for Migration, IOM, can assist in obtaining documents, but that is an optimistic stance not rooted in any guarantee from the IOM. Many countries routinely refuse to issue travel documents for citizens it considers adversaries.
Jamaica, when you see the liar we come from Colin Bell show is on point. The man them say for the US get documents, them cannot guarantee getting documentation for the persons them what them are saying. Because many countries routinely refuse to issue travel documents for citizens. It considers adversaries. Mighty God.
Adversaries. A person who refuses to apply for their home country's passport because they fear that very act could expose them to surveillance, punishment, or denunciation at home is in an especially difficult position. International protection principles recognize this concern. Refugees often cannot safely use their national passports precisely because doing so would involve contact with the persecuting state. Antigua and Barbuda's practical exposure. Once a person physically arrives on Antiguan soil, even one the full weight of international legal obligations attaches. The non-refoulement obligation under the 1951 Convention applies. The 1954 Statelessness Convention obligations apply if the person has no documents. The absence of a dedicated refugee law means the government must manage these individuals through improvised administrative channels, with no statutory framework for their long-term status, work rights, or eventual durable solution. In short, the person would arrive in a legal gray zone, simultaneously a potential asylum seeker, a de facto stateless person, and an undocumented migrant. With Antigua and Barbuda holding treaty obligations, it has no domestic legislation specifically designed to fulfill and very little means to undertake. It is precisely because of this legal exposure that the government has insisted on stringent preconditions before any transfer can be contemplated.
Jamaica, what I'm understanding from this, is that, these people, through this statelessness in another country, could be subjected to abuse quite easily. At this part where it said the absence of dedicated refuge law means the government must manage these individuals through improvised administrative channels with no statutory framework for their long-term status, work rights, or eventual durable solutions. Let's continue.
Contemplated. 3. Background to the issue. On December 19, 2025, Antigua and Barbuda and the United States signed a Memorandum of Understanding concerning the possible transfer of certain third country nationals from the United States to Antigua and Barbuda. 6. That Memorandum of Understanding is expressly non-binding. It does not create a standing program of admissions. It records only a framework for possible cooperation under which the United States may propose transfers and Antigua and Barbuda may, In its complete discretion, consider accepting such proposals in whole or in part on a case-by-case basis. The Memorandum of Understanding also provides that, before any transfer, the United States intends to provide biographical, medical, and criminal documentation to the extent available and permitted by law. It further affirms that all action taken under it should conform with the international legal obligations of both governments, including refugee law, the Convention Against Torture, and the principle of non-refoulement. It also preserves the right of either participant to discontinue its participation at any time, while endeavoring to provide 90 days written notice through diplomatic channels. Following signature of the Memorandum of Understanding, the United States transmitted a series of draft operating procedures intended to put the arrangement into practical effect. Those drafts evolved over time. In general, however, they proposed a more programmatic arrangement than that reflected in the Memorandum of Understanding itself. They introduced monthly numerical ceilings, broadened the categories of eligible persons, proposed compressed timelines for notification and approval, relied on documentation only if available or known to the United States, and left key issues of funding, legal status, settlement, onward movement, and return responsibility unresolved. In response, Antigua and Barbuda identified material concerns and made clear that no operational arrangement could responsibly proceed unless those concerns were addressed in writing and on terms consistent with the country's size, capacity, laws, and national interest. The government of Antigua and Barbuda has since developed and transmitted its own counterproposal for operating procedures. That counterproposal is based on the original Memorandum of Understanding, reflects Antigua and Barbuda's sovereign interests, and is offered in a spirit of friendship and cooperation. 4. International and regional context. The discussions between Antigua and Barbuda and the United States do not occur in isolation. The use by the United States of third country arrangements for the removal of non-nationals has become a wider feature of its migration policy. Publicly acknowledged arrangements have involved a number of other countries, including in the Americas. Public reporting also indicates that some Caribbean states have been approached and that several have agreed in some form to receive a limited number of persons under understandings with the United States. 7. This wider context matters for two reasons. First, it confirms that Antigua and Barbuda is not the only country dealing with this issue. It is part of an established and expanding policy practice. Secondly, it underlines the need, as a small state, for Antigua and Barbuda to proceed with care. For large countries, questions of reception, housing, healthcare, legal status, public order, and onward return may be difficult but manageable. For a small island developing state with limited land area, a small population, constrained public finances, and already stretched public services, the consequences may be severe. The policy has also been the subject of litigation in the courts of the United States. Courts in the United States have ruled that removal to third countries without notice or opportunity to raise protection claims violates due process, reinforcing Antigua and Barbuda's view that the legal framework governing these transfers remains unsettled even in U.S. domestic law. While the United States has continued to pursue the policy, the existence of litigation has reinforced Antigua and Barbuda's view that any arrangement must rest on clear, careful, and defensible terms. 5. Why Antigua and Barbuda is considering the matter at all. The government considers it important to explain plainly why Antigua and Barbuda has engaged this issue. Antigua and Barbuda is considering the matter because it values its friendship and cooperative relations with the United States and is prepared, as a responsible member of the international community, to examine requests made by a close partner. Consideration of such a request does not imply automatic acceptance. It reflects the government's view that a serious request from a friendly state should be examined seriously, carefully, and on its merits. The government must also take account of the wider.
Yo, there, hey man, this man is good. He know he walking on a tightrope. Oh man, this brother is good. It doesn't mean that it's automatic acceptance, you know. But we are going through it and considering all the variables. Yes.
Wider regional setting. Several Caribbean states have already entered into, or publicly acknowledged, understandings with the United States concerning third country nationals. These include, among others, St. Kitts and Nevis, St. Lucia, Guyana, Jamaica, and Belize. In that context, Antigua and Barbuda cannot ignore the possibility that any government which has not done so may be viewed in Washington as less cooperative than others. This does not relieve Antigua and Barbuda of its duty to protect its own sovereignty, laws, capacity, and national interest. It does, however, explain why the government has chosen to engage the issue seriously, to define its position carefully, and to proceed by measured negotiation rather than by impulsive refusal. 8. 6. The core issues for Antigua and Barbuda. The government's examination of the matter has identified a number of core issues. A. Sovereignty and control. Antigua and Barbuda cannot accept a standing operational pipeline under which persons are sent as a matter of routine or expectation. Any arrangement must preserve Antigua and Barbuda's complete discretion to approve or refuse each proposed individual and to determine the number, if any, to be accepted at any given time. B. Legal status on arrival. No arrangement can...
Now, for the sake of not having this particular reaction be too long, ladies and gentlemen, we're going to go and end this particular recording to be part 1 of 2. And then on part 2, we're going to come back right here. So the core issues for Antigua and Barbuda. Alright? So please remember to like, share, and subscribe. Thank you very much.